Mrs. Elmer Gantry, the appellant, visited the Green Thumbs nursery, the respondent, to look at roses. The rose display was connected to the rest of the nursery by a passageway, the floor of which was tiled. The tiles of the passageway were wet. Water had been sprayed onto them inadvertently by an unknown person watering the roses. After inspecting the rose display, Mrs. Gantry slipped on the tiled floor in the passageway. Although she usually wears glasses for short-sightedness, she was not wearing them while inside the nursery. Mrs. Gantry brought an action in negligence against Green Thumbs Nursery, was unsuccessful in the District Court, and is now appealing to the New South Wales Court of Appeal.
In the matter of Elmer Gantry and Green Thumbs Nursery, the New South Wales Court of Appeal is now in session. This court will now take appearances.
May it please the Court, Your Honours, my name is Lyndon Goddard and I appear for the appellant, Mrs. Elmer Gantry, in this matter. With Your Honours' permission, I will limit my submissions to 10 minutes. I will deal with the submission points regarding breach of duty and contributory negligence.
Appearances take a particular form. This can be found in the UNSW Mooting Handbook, which is distributed to registered competitors. During appearances, counsel introduces themselves and their client, outlines the length of their oral submissions, and indicates which of their team submissions they will be addressing.
Thank you, counsel.
Mr. Goddard?
Your Honours, this appeal concerns the injuries suffered by the appellant when, while visiting the respondent's nursery, she slipped and fell upon a patch of wet tiles. The nursery did not display a sign warning of the possibility that the tiles might be wet. As a result of the accident, the appellant has suffered substantial injuries. The appellant seeks now to overturn the finding by the trial judge that the respondent was not liable in negligence.
Here, the senior counsel has provided a brief summary of the facts of the case. Note that it is about 30 seconds long, is not overly slanted to the appellant's position, such that it may attract unwanted early questions, does not raise any issues of law, and does not go into great detail.
Your Honours, it is agreed between the parties that the respondent owed the appellant a duty of care. I will therefore make two submissions. First, the respondent breached his duty of care to the appellant in two distinct ways. Second, the appellant was not contributorily negligent.
Often, the existence of a duty of care is not controversial. Here, counsel has acknowledged this. He has notified the judges that he will move on to breach of duty, allowing him to focus on a more contentious point. Generally, you can concede an argument that is not fatal to your submission. This is especially appropriate where the judges are persistently questioning you on a minor or tangential aspect of your submissions. Making a smart concession in such circumstances gives you more time to focus on the controversial and important issues in the moot. Here, counsel has clearly outlined to the judges the two submissions he will make. This is called signposting, and he will continue signposting wherever appropriate to allow judges to follow his train of argument. Signposting is most helpful when there are two or more parts to an argument, concept, or legal test.
Turning to the first submission, we submit that the respondent committed two distinct breaches of its duty of care. One, it failed to erect a sign warning customers that the tiles may be wet. Two, it failed to place a mat on the floor to improve the grip of the tiles in the event that they did become wet. Your Honours, the test for a breach of duty was set out by Justice Mason, as he then was, in the case of Wyong Shire Council and Shirt, reported in 1980 in volume 146 of the Commonwealth Law Reports, beginning at page 40. May I dispense with formal citation, Your Honours?
You may, counsel.
If you are senior counsel, always ask your judges if you may dispense with formal citation after the first case that you cite. Also remember that for beginners mooting at least, you will not be expected to refer to legislation, and so the moot will proceed as if, in this case, the Civil Liability Act does not exist.
Your Honours, the test in Wyong Shire Council and Shirt has two elements. The first element is whether a reasonable person in the respondent's position would have foreseen that his or her conduct would involve a risk of injury to the appellant or to a class of persons including the appellant. The risk cannot be far-fetched or fanciful.
Do you have a page reference for that principle, counsel?
Yes, Your Honour, that is at page 47 of the report, near the bottom of the page.
Thank you.
Your Honours, the relevant risk here is that a visitor in the nursery would slip on wet tiles and suffer an injury. Applying the first element of the test in Wyongshire Council and Shirt, we submit that it was not far-fetched or fanciful that a visitor to the respondent's premises might suffer an injury as a result of a wet patch on the ground. It is entirely foreseeable that a person may slip on wet tiles, and tiles are hard surfaces that can cause injury. On that basis, we submit that the first element is satisfied.
Counsel has made sure to employ the words used in the relevant legal test, being far-fetched or fanciful. He has also made reference to the facts of the problem. Being on top of the law and the facts, and explicitly applying the law to the facts, will endear you to judges.
Turning to the second element of the test in Wyongshire Council and Shirt, it must be shown that the response of the respondent to the risk of injury fell below what would have been expected from a reasonable person in the respondent's position.
Counsel, what are the factors that inform what a reasonable person would have done?
Your Honours, there are three factors to consider. First, the likely seriousness of the harm. Second, the probability that the harm would occur. And third, the burden of taking precautions. I will deal with each in turn.
What is your authority for this, and how are these factors to be applied, Counsel?
Your Honour, these factors derive from Justice Mason's judgment in Wyongshire Council and Shirt, where His Honour explains that it is necessary to weigh these elements against each other in order to determine what a reasonable person would do in response to the risk of injury. When applying these factors, the conduct of the respondent in this case is compared to the standard of care. Turning now to the first of those factors, the seriousness of possible harm, it is common that tiles, when wet, become slippery. Entrance to the nursery could easily slip on the tiles and fall, as the appellant did. The resulting injury would likely be of a serious nature, given that tiles are hard surfaces. Indeed, that is borne out by the facts of the matter before the court.
How would you evaluate the probability of harm?
Moving then to the probability that the harm would occur, we submit that a large number of people would be expected to pass through the nursery on any given day. Some perhaps with prior experience with nurseries, and some perhaps without that experience. It is possible that those with experience in nurseries might be expected to have looked out for water on the tiles, but those without such experience may not have been so expected. We therefore submit that there was a high probability of harm arising from the level of care exercised by the respondent in this case. Furthermore, if I may take your honours to paragraph 5 of the facts, at the bottom of page 2, it is clear that Mrs. Gantry had no prior experience with nurseries. We therefore submit that the probability of harm was high in this case.
Note the counsel pointed the judge to a specific paragraph in the facts. If you're relying on a specific fact, it is helpful to take your judges to it and provide as much detail as possible to assist them in finding it. If you have deviated from your written submissions after a long line of questioning and are returning to them, it will also be useful to take your judges to the paragraph in your written submissions that you are starting from. It is not, however, necessary to point to the corresponding paragraph of your written submissions at every stage of your argument.
Counsel, you said that Mrs. Gantry had no prior experience with nurseries, but isn't the standard of care inquiry to be conducted prospectively, that is, without the benefit of hindsight?
Yes, Your Honour, but I'm simply making the point that the appellant was a member of the class of persons without experience in nurseries, and that the presence of that class of persons, generally in the nursery, was reasonably foreseeable to the respondent.
And how would you evaluate the burden of taking precautions?
Moving to that final element of the test in Wyongshire Council and Shirt, we submit that the respondent could easily have placed a sign or signs reading "danger, wet floor" or something similar, and it could have placed rubber mats at the entrance to the tiled passageway. Such precautions would not in any way have been burdensome, either in practicality or in cost. We therefore submit that it constituted a breach of duty to fail to undertake either of those precautions.
Counsel, is it necessary for us to accept that both the failure to erect a sign and the failure to install mats were breaches of duty, or is one sufficient?
Your Honours, it is sufficient to establish one breach of duty in order to found liability in negligence. Authority for that proposition might be found in the judgment of Justice Mason in Wyongshire Council and Shirt at page 47, where His Honour notes that the question is whether there has been a breach of duty. The two breaches we have identified in our submission are therefore alternatives to one another.
Counsel has just demonstrated effective use of a pause. As you are speaking for 20 minutes, feel free to take your time and provide clear answers to questions.
Thank you, Counsel.
Your Honours, I now turn to my second submission, which is that the appellant's failure to wear her glasses did not amount to contributory negligence. Your Honours, in order to prove that the appellant was contributorily negligent, the respondent must show that the appellant failed to take reasonable care for her safety and contributed, by that lack of care, to the injury or damage that she suffered. For this principle, we rely upon the case of Astley and Ostrust at paragraph 21. Mere thoughtlessness or inattention is not sufficient to establish contributory negligence, as explained by Justice Windia in the case of Sungrow Viewer Proprietary Limited and Miani at pages 37 to 39.
Counsel, why was the appellant's actions in not wearing her glasses not enough to constitute contributory negligence?
In our submission, the appellant's failure to wear her glasses was an omission that a reasonable person could make. The reasonable person is not infallible, and such minor errors are entirely possible. Moreover, the appellant was short-sighted, not long-sighted, and therefore would have been expected to see the state of any floor she walked on relatively well, even without her glasses on.
If I understand your submission correctly, Counsel, you are saying that if the appellant was long-sighted and had failed to wear glasses, she was more likely to have been contributorily negligent?
Yes, Your Honour. In our submission, a failure to wear glasses if one were far-sighted would be a riskier activity, since one's ability to see dangers on the floor would be more significantly reduced.
If asked a yes or no question, start your answer with yes, Your Honour, or no, Your Honour, then explain why. If you don't know the direct answer straight away, it is better to pause for a moment before responding, rather than giving a rambling response and ending with an answer.
Additionally, Your Honours, we submit that the context should be considered. A visit to a nursery is not usually a dangerous situation that requires large amounts of care to be taken. It is not as though the appellant had been attempting to ice skate without her glasses on, for example. She was merely walking through a store. We therefore submit that the appellant's conduct did not rise to the level of contributory negligence. The appellant's failure to wear her glasses was, quote, excusable in the circumstances because it was not incompatible with the conduct of a prudent and reasonable person, as identified by Justice Windia in the case of Sungrow Viewer at page 37.
Here, counsel has made good use of a hypothetical fact scenario, ice skating without glasses on, to make a more persuasive argument. However, it is important to not make your scenarios too outrageous, as it may distract the judges and take away from the persuasiveness of your argument. Judges may also present you with hypothetical fact scenarios to test your understanding of the law and the strength of your submissions.
Your Honours, we ask that the appeal be allowed, the decision of the trial judge be set aside, and the appellant be awarded damages. Unless I can be of further assistance to Your Honours, may it please the Court, those are our submissions.
Thank you, Counsel.
Orders are typically done by junior counsel. Although counsel in this video is senior counsel, we've included orders as an example. After giving the orders, end your submissions with, may please the Court, those are our submissions. You will notice that counsel frequently refers to the judges as Your Honours and has the utmost respect for the Court. He always says we submit, not I think, argue, believe, or feel. He also never interrupts the judges when they are speaking, even if they interrupt him. These are important formalities in courtrooms and are usually observed even more strictly in mooting competitions. Nevertheless, you should generally try to present yourself as naturally as is reasonably possible, rather than coming across as stilted and awkward. Above all, remember that mooting should be thought of as having a formal conversation with a judge, which is exactly what barristers do. Appearances, orders, and formal citation have a set form. These, along with a list of court formalities, can be found in the UNSW Mooting Handbook.